Good morning, ladies and gentlemen. How are you all doing today? Okay, great. I am Judge Tinkler Mendez. Let me welcome you here. I know we did our virtual pre-qualification the other day, and we were able to kind of narrow down our group. And you are all here now for our live proceedings of jury selection. The case is the state of Florida versus Terrence Davis, and that is F214391 for the record. I welcome you all to the Richard Gersten Justice Building, and I want to say how grateful we are, ladies and gentlemen, to have all of you as citizens of this community attending to your duty and obligation to serve. We know that this is a disruption for you. It's an inconvenience, but there's only a few things that our country requires us to do as citizens. Pay your taxes and serve on a jury. Let me tell you why. It's very simple. This branch of government, the judicial branch of government, is the only branch of government essentially operated and controlled by the people. You are the people. This branch of government is essential to the balance in government. To have the citizens make decisions. And that's why you're here. And that's why it's necessary for you to be here. We don't operate without you. That's the bottom line. Without the branch of government that you are operating in as the citizens that you have the control over, there would be chaos. That's how important it is. This is the highest duty that you can serve to your government, or our government, absent serving in the armed services. So we understand the sacrifice, we understand the inconvenience, but note the importance and necessity for you to do this job. Okay? And, fortunately, this is going to be a pretty short trial. We're going to select the jury this morning. And then those of you who are selected to serve on the jury will return tomorrow morning, and we will start and finish the rest of the trial. You will have the case for your deliberations by tomorrow afternoon. That's what we expect. All right. So thank you again, ladies and gentlemen, for attending to your obligations, doing your duty. We are so proud of all of you and proud of the citizens in this county for the responses that we have gotten. Frankly, the last few months, we have been operating in this fashion. It's been a very, very difficult and unprecedented 15 months for the world. And some were sadly more affected adversely than others, but we keep moving forward. And on that note, with regard to wearing masks, the courthouse is going to officially be open for public in less than 2 weeks, about a week and a half. We are still operating with the following protocol of being conservative so that you all feel comfortable while you're here serving. If you have any concerns throughout the proceedings, make sure you let my bailiff know. But we are going to continue to maintain social distance. As you're seated here, you are all seated in that fashion. There is some flexibility, though, in terms of your ability when we take a break to kind of move out of this area. But we tell you that you may continue to wear your mask. Okay. Some of the parties may decide not to wear their mask, and they are going to continue to maintain appropriate safe distance so that, again, we don't make anyone here feel uncomfortable. But the protocol and the safety measures that we have been taking for months have been working quite well. So I just wanted to let you all know that. And let me tell you a little bit about what's going to happen. This process known as voir dire, and I have to stand up because I'm a little short, and if I sit down, I'm told it looks like I'm sitting in a closet and you can't really see me. So I prefer to stand up. This process known as voir dire, jury selection, literally means to see and to seek the truth. To see and to speak the truth. And the purpose of this part of the trial, which is a critical part of the trial, is to select a group of people who will be fair and impartial and judge the case only based on the evidence presented in the courtroom and the law that I will give you. You may not be the right juror to sit on this particular case. The key here is to communicate with us. We have a short period of time while we have your responses to questionnaires. It's very limited. The attorneys will go through a series of questions with you. We want responses. We want participation, so we know what you're thinking and how you feel. You cannot serve on this panel as a juror and base your decision on your emotions, on your feelings, on your sympathies, on your bias. It is not permitted. The reason is simple. We have to be able to rely on your decision as a fair and just decision. It's the best system in the world, not perfect. But it depends on the jurors. It depends on your honesty and openness. We're not here to embarrass anyone. We're not here to make you feel uncomfortable. That's not the purpose of what we're doing in trying to gather information from you. You've all had different life's experiences. You bring those here. You also bring your common sense. We expect you to use your common sense. You're not going to ignore your life's experiences, but what you might need to do is explain your life experiences to us. And you might be in a situation where you have to think, well, I might have had a certain life experience, but I am not going to allow that experience to interfere with my objective assessment and review of the evidence that I am going to hear. Can't let it interfere. Okay? We'll talk more about this as we go through the voir dire. So that's your job here. Your job is to be honest with us, open with us, truthful. If there's something you want to tell us privately, you let us know. We'll make those arrangements to do that privately. It's a little more difficult because we're operating in this fashion, but we'll make it happen. Okay. So as I already told you, this is the case of State of Florida versus Terrence Davis. And in this case, Mr. Davis is accused of one count of being a convicted felon in possession of a firearm. That's the allegation. And Mr. Davis is put on notice of that through a charging document known as information, which is not evidence, which is not proof of anything, but the Constitution says if the government is to accuse a citizen of committing a crime, they need to put them on notice as to what that allegation is. And it's done with a document. This is going to lead me into a very brief discussion, ladies and gentlemen, of some of the very special rules of this house. You are in a criminal courthouse. This is a criminal court proceeding. There are unique, special laws of criminal law and constitutional law that you as jurors must promise to follow. You have to promise us you're going to follow them. So that, again, we know that whatever decision you make is a fair and just decision. And based on the evidence and the law. That's it. Let me talk to you briefly about what these rules of this house are. Actually, before I do that, let me make some introductions. Again, there were some introductions made virtually. It's a little different now in person. So we're going to do that again. All right. I'm going to ask the parties to introduce themselves and please announce prospective witnesses. Yeah, I'm going to let them introduce. Please introduce yourselves. Please also remember to use the microphone. Very well.
Good morning, everyone. My name is Yaneli Zamora, and I, along with Mr. Brody, have the honor and privilege of representing Mr. Terrence Davis.
All right, very well. Now, we'll hear again the... Use the microphone, please, counsel. Thank you. Got to turn it on. There's a little button there. You can pull it out if you wanted to. Very good. Go ahead, counsel. Button goes up. There you go. All right. Where's Robert?
Thank you, Judge. Anna Meridian on behalf of the state of Florida. I'm going to announce the witness list now. Sylvia Moses, Tavari Harrell, Omar Roll, Gary Jones, Pinky Jokum, John Stanley, Dimitri Edward, Edwin Castro, and Anthony Roach. Thank you, Ron.
All right, in addition, I'm going to introduce my clerk, Chris, who's sitting all the way over there. Chris's responsibilities, he takes care of all the files and records in the case, keeps me on track. And he's over there now, taking notes and preparing documents related to this case. I have my court reporter, Lorena Ramos, sitting right here. Both Lorena and Chris have been with me for years. I sometimes wonder how they have sustained that camaraderie with me for that period of time. They're fabulous, absolutely fabulous, A-plus teamers. I've been extraordinarily fortunate in the years that I've been serving as a circuit court judge in this division. So thank you so much. You've already met my bailiff as well. He's probably running around checking on several things. That's Robert. Now, anyone here recognize anyone who's just been introduced or introduced themselves or any of the names that were listed? If so, I need you to raise your hand and please identify yourself by your seat number and your name. I'm looking, are there any hands? I do not see any hands. Very well. Now I'm going to go back. Rules of the House. I started to talk about that. To sit as a juror in a criminal case, there are very specific, clear rules of the House. We call them that because they're unique to these proceedings, criminal court proceedings. It's not a civil case, not a civil case. Civil cases are about, contract dispute, money, property. No, this is a criminal matter. And by the Constitution and law, criminal law, there are extraordinarily important parameters. These are the blueprints, basically, for you as jurors to follow, very clear, in order to do your job properly. The instructions, okay? So let me go over a few of them with you. First, in every criminal case in our country, the person accused, you might hear person is referred to as the defendant. In this case, Mr. Davis, Terrence Davis, as the accused, is presumed innocent. He is here because the trial is the only forum, the only place that this dispute is heard. He's innocent. He's been accused of committing a crime. That's it. That presumption of innocence remains with Mr. Davis throughout the proceedings, unless the state over here can overcome that presumption of innocence by presenting evidence to prove guilt beyond and to the exclusion of every reasonable doubt. Highest burden under the law. Why is that? Because understanding what this is about, to protect all citizens, the framers of the Constitution said, if the government is going to accuse a citizen of wrongdoing, we have to place that high responsibility on the government to prove that there was wrongdoing. And it's that high burden under the law that they're required to meet. Rule number 1 of the House, this man is presumed innocent, which means he is. He's accused. Okay. Second, as I mentioned, how much evidence does the government have to present? Well, that highest burden under the law is proof beyond and to the exclusion of every reasonable doubt. And I'd like to read to you, and I want you to remember, at the end of the case, I am going to tell you what the law is. We're not here, and you're not here to change the law. We must follow the law. Okay? One of the legal instructions that you're going to get, and you're going to get it in writing also, is what is reasonable doubt? How is it defined by law? Now, let me say also, it's going to sound a little complicated, and we'll try to simplify it for you. Let me read it to you, though. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, from the lack of evidence, or from a conflict in the evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Reasonable doubt, basically simplifying, if at the end of the case, after you have heard all the evidence, final arguments of the lawyers, the instructions on the law, you go in and you begin your deliberations. And if you have a doubt as to the guilt of Mr. Davis, that you can attach a reason to, a reasonable reason, not a speculative reason, not an imaginary reason, then your verdict's not guilty. If you do not have a doubt, any doubt based in reason, your verdict must be guilty. Okay? How many of you have served on a jury before? How many in a couple of you? How many in a criminal case? You've served on a jury in a criminal case. A few of you. So this is a repeat. This is a rehearsal again. But I ask you again to please listen carefully and follow along. Most of you are new to this process. That's why I'm going through this with you, to give you the blueprints, to give you the job description and the parameters of how you do your job. Okay? Rules of this house. They, meaning the state, they have the entire responsibility, another rule of the house, to prove the allegations they bring against the citizen, Mr. Davis, by evidence beyond and to the exclusion of every reasonable doubt. That's it. Nothing less, nothing more. I'll tell you this, they have no responsibility to prove absolute doubt, absolute guilt. Why? That'd be impossible. Why? Because you'll all be witnesses to whatever happened. You understand? But they have to prove guilt beyond every reasonable doubt. Okay? The burden always stays with them entirely. It never shifts to the defense. They have no responsibility. They don't have to prove that Mr. Davis is not guilty. Okay? They don't have to disprove guilt. Now, I suggest that the lawyers, even though we say they could sit here and do crossword puzzles, if they don't present sufficient evidence beyond a reasonable doubt, two things: one, that a crime occurred, and two, that Mr. Davis is the person who committed the crime, it's not guilty. Okay? I doubt they're going to sit here and do crossword puzzles. You know, I suggest they may ask questions of witnesses they're called to testify. What comes from the witness is the evidence, not what the lawyers ask them. But the point being here, the state has the responsibility of presenting evidence, properly so, as they bring the allegations, and it always stays with them. Okay? You cannot, rule of this House, impose any burden or responsibility on the defense to do anything. If you do that, you're not doing the job that we're asking you to do here. That's why I'm telling you the rules. And you have to tell us if you can follow those rules to do this job. Hand in hand with all of this, another rule of the House, fundamental right that Mr. Davis has to remain silent. He doesn't have to testify. He doesn't have to do anything. Remember, I said the defense doesn't have to present any evidence, right? They have no responsibility. Testimony is evidence. Witnesses testifying. That's a type of evidence. So it makes sense that Mr. Davis doesn't have to testify. And you cannot consider it in any way in determining whether or not the state has met their burden of proving guilt beyond every reasonable doubt. You can't hold him responsible or speculate if he exercises his right not to testify. It's a rule of the House. Plain and simple. Okay? Important rule of this House. Let me tell you as an example how I think, and this sometimes troubles people. They say, well, I understand the rules of this House, but the way I operate my house is very different. So I'm uncertain whether or not I can follow the rules of this House. So I want to give you an example of where that might, come into your mind. You'll be here for a few hours, jury selection. Afterwards, you go back to work or whatever other responsibilities you have. You go home. How many of you have children at home? No. You may not have at home, but if you have children at home, all right, let me use this example. And everyone else who doesn't have children at home, just bear with me. You get home and the children are sitting and watching television in the family room. And you had a very nice centerpiece on the coffee table in the family room, but that is now on the floor in 1,000 pieces. And there's a soccer ball on the floor next to it. I would suggest the rule in your house is not you have a right to remain silent. Okay? But just because that's the rule in your house does not mean you cannot, and does not mean you're not capable of following the rule in this house. You see, I point that out as an example. Sometimes people question their abilities. I'm telling you what the rules are here, and you have to say, this is the job description. Can I do the job? Okay, because you're here to do the job now. You may not have wanted to be here, but you're here. So the question becomes, can I do this job? That's just an example. Even though the rule in your house is different, these are the rules here, and you have to promise to follow them. We have to know that whatever decision you make is a fair and just decision. Okay? You as the jury panel, you are going to determine credibility. Credibility is whether or not you can rely on what information you're receiving, what a witness is telling you. I'm going to suggest you make these determinations all the time You are sizing up people and situations all the time that you are confronted with to determine whether or not the information you're being given is something you can rely on and you find believable. Okay? So you use skills that you don't not even aware of. You look to how is the person acting when they're testifying? Eye contact. Have they said something different at a previous time? You know, inconsistencies. How good is their memory? How good is their perception of the events that they're describing? My Cousin Vinny, anyone see the movie? I've seen it 4,000 times. Each time I get something new out of it. In My Cousin Vinny, there's a witness testifying, older lady. And she finishes her testimony. The prosecutor is asking questions, finishes. The defense lawyer comes up and starts asking some additional questions. And through the responses of the witness, it becomes clear the following. She testified that she saw certain events. Well, through cross-examination, it was learned that the witness wasn't wearing her glasses, was a great distance away, was looking through a dirty window with trees blocking the view. You would have to, as a juror in that case, evaluate that witness's ability to see and know the things about which she's testifying about. Perception. People are untruthful. Human beings. They could be mistaken, confused. That's how you will judge credibility, ladies and gentlemen. That's your job. You are the judges of the facts. You determine what the facts are, what the facts are. You are given the law by me, and you must determine whether or not the state meets their responsibilities under the law to prove that Mr. Davis committed the crime charged beyond and to the exclusion of every reasonable doubt. Okay. So that's kind of the overview that I wanted to give everyone. I'm going to sit down, but I will warn the attorneys. They haven't seen it beforehand. I apologize. I'll be interrupting, I'm sure, while you're asking questions to kind of help flesh out and induce you all to participate, give us information. So I apologize beforehand because I will do that. Now, ladies and gentlemen, one thing I also need to do before the lawyers do begin is I'm going to ask you to all stand, raise your right hand. I don't think any of you have spoken yet, but do you swear or affirm that any testimony you have already given or about to give will be the truth, whole truth, nothing but the truth? Say I do, or say I don't. Okay, everyone has said I do. Thank you. You may have a seat. All right, for the state. And you gotta use the mic. Robert,
May it please the court.
go. Thank you, Robert. We're good on the mic.
Anna Marie Daniel on behalf of the state. Hello, everyone. This is a bit difficult because this is a different setup than I'm used to. I can't see some of you, and I'm really, Judge, may I
You
step?
can move around.
Right.
Just remember to
Not
keep
to get too close.
a safe distance.
Sorry, ma'am. It's hard because we're used to having a podium beside us. So I'm going to walk around and do my best, okay? And maybe try to stay close to a table. But I've taken my mask off, as you can see. I don't have it on. If that is uncomfortable for any of you, please let me know. Anybody? Is that uncomfortable for anybody? The mask. You would prefer I keep my mask on? Oh, okay. Is it uncomfortable? Okay, I'm going to move forward because I don't see anybody saying, Miss Danilo, put your mask back on. Now, as the judge has introduced my colleague and myself, Miss Jennifer Garcia, we are the state of Florida. We are assistant state attorneys, and we represent the state of Florida. We are the prosecutors. As the judge also mentioned, we have the burden to prove beyond a reasonable doubt that a crime was committed and a defendant committed a crime. That's our burden. We are going to bring the proof and we are going to bring the evidence. Does anybody here not understand that? Does anybody here say, I've never heard of these things before. I don't know who this lady is, and I don't understand why she's talking to me? No? Okay, I don't see anybody raising their hands. So setting that aside, some notes to jot down, which I've jotted down, but I can't really continue jotting down. But I am going to provide to you the law in this case, because I think it's important that we talked about it. I know the judge is going to provide the law later on. For those of you who are selected, you are going to get jury instructions, and it's going to have all the instructions and all the legal knowledge that you need to know for this case. Nothing outside of it. Everything you need is going to be in these instructions if you're selected. I'm going to be asking you these questions not to be nebby, not to be in your business, not to make you feel bad, not to even try to even start a real fight or a conversation over the issues. As the judge said, we have a limited time. So as much as I would like to debate the politics and the reasons and the policies, that's not for here. I'm going to be asking you some quick questions, yes or no, brief explanations, and if we move past you, don't take offense to it. Okay? Everyone back here, can you see me? Hi? All right. So I'm going to start. I don't want to butcher it. I'm going to read it off, even though I know it. The elements of the crime charged here is that the defendant had been convicted of a felony, and after the conviction, the defendant knowingly owned or had in his care, custody, control a firearm. The word firearm. Does that concern anybody in this case, knowing that this case involves a firearm? I don't see anybody raising their hands. How about behind this pillar? Is anybody concerned that this case involves a firearm?
Ms. Dano, would you be careful with the mic because it's giving a little background.
Ooh, sorry, Judge.
Yeah, there you go. Like it. Yeah, you gotta kind of hold it steady. Okay, go ahead.
Sorry, we're used to podiums where we don't get to touch the mic.
Right.
I'm gonna come and I'm gonna try to ask each of you individually. Now you are all spread out, so this is gonna be a bit tough. Can I please go to juror number 1?
Seat number 1,
Seat number 1,
Brianna Acosta.
here.
Brianna Acosta. Go ahead, counsel.
Miss Brianna Acosta, do you have any strong feelings with regards to firearms? No. How about Miss Esperanza Alonso, juror number 37?
Seat number 37. Let's call
number
him
30.
seat number.
My
Okay.
apologies, Judge.
All right.
Number 2, juror number 37, but we're going to go by seat number.
Guys, let's not be confused. I need the name of the individual juror that you're speaking with.
Esperanza Alfonso, seat number 37.
Number 2.
She's in seat number 2, counsel. Just say
Oh, juror 30. My apologies.
counsel.
Judge.
Seat number 2.
Seat number 2, Alfonso Esperanza. Miss Alfonso, do you have any strong feelings with regards to firearms?
What's wrong? What?
Do you have any strong feelings about firearms? You hate firearms.
Yes.
So is it going to be a problem for you to be on this jury and listen to facts about firearms and even possibly see a firearm?
I won't be traumatized for this, but I hate firearms.
Okay.
Really.
Counsel, can I see you up here with the defense? I don't need the court reporter. No, the red means that, there we go.
Red means it's off.
You're good.
Okay. So does anybody else share? So we have two opposing sides here, right? We have somebody who has no problem. This seat number 1, Rihanna Acosta, she has no problem with firearms. And we have seat number 2, Miss Esperanza Alfonso, who says she hates firearms. Is there anybody else who hates firearms? I see somebody way in the back.
Tell me your name and seat number and your name.
Seat number. I will learn. I've learned.
Seat number, please, and name. Thank you. Come on, guys.
58.
Seat number 58.
No, there's no,
Sandra Turo.
what is the juror's name, please?
Turo Sandra.
Go ahead.
Okay. So you raised your hand in response to my question.
Yes.
Okay. What is your feeling on firearms?
I completely disagree with them. I think they shouldn't exist.
Okay. Knowing that you feel that way, would you be able to follow the law in this case and be a fair and impartial juror? You've
I'm-
shrugged your shoulders.
I'm
What-
not sure.
You're
don't-
not sure.
Yeah, because I just strongly disagree with them. So
Okay. Thank you very much. Who else raised your hand back here? And if you can give your seat number and name.
Number 35, Marisol Pardo.
Okay.
I just think firearms are meant for law enforcement, and that's what they should say.
Okay. Thank you very much. I appreciate it. Is there anybody else who has an opposition? Oh, I have people over here as well. Can you please give me your seat number?
My name is Vivian Connor. I'm
Seat number 8, Vivian Connor. Can you please tell me, do you have a response to what the previous juror said?
well, I'm afraid of firearm. I just don't want to be near them. I don't disagree with whoever wants to carry them legally, but I just don't want to be near.
Okay.
I don't want to talk about it.
So will that impact your ability to sit on this jury though? You have your personal feelings.
Yeah.
How would that impact your ability to sit on this jury?
And the question, ladies and gentlemen, again, is this. You're entitled to we want to know your personal feelings. You either don't think that people should have firearms or only law enforcement. The law allows people to have firearms. Okay, that's what the law is. The accusation in this case, there are 2 parts to this crime. One is the state has to prove that Mr. Davis used or possessed, had in his possession, a firearm. Okay? Excuse me, not used, owned or had in his possession a firearm or carried. Okay? Not carried. Possessed a firearm. The other part is that he's a convicted felon. Those are the 2 parts of this crime. Okay? The fact that you may be against people owning firearms or having firearms, the law allows for that. This case is not about the use of a firearm or a firearm being fired or anything like that. I want to make that clear to all of you. It's about someone, because the law says if an individual is a convicted felon, they are not permitted to possess a firearm. That's it. That's what the law says. Okay? So it's nothing more than that.
So, seat number 8, Ms. Connor? Knowing what the judge just said, would you be able to be a fair and impartial juror on this trial?
It's very difficult, it's very difficult to me to judge somebody. So
Okay.
I really don't, I don't
Okay.
know. I just leave it up to God. I don't know.
I appreciate your honesty. Can you please provide me your seat number 14? Seat-
Number 14, yes.
And what is your name, sir?
Wilson Hurtado,
Hurtado.
yes.
Okay, my apologies if I butcher your name. Go ahead. If it's in response to what the judge just said or your fellow jurors.
I don't feel comfortable. 2 years ago, my dear coworker was assassinated. Here around now with a fire alarm, and right now I don't feel, not even talking about it.
Okay, let me jump on that. The elephant in the room. Let me deal with that with all of you now. Okay. This gentleman here, Mr. Terrence Davis, cannot and should not be held responsible for what you might be hearing in the news, the proliferation of use of firearms, gun violence. That's not his burden to bear. It would be unfair and improper for any juror to hold him responsible because of feelings, things you read about, things you hear, because that's not evidence. And then you'd be basing a decision on emotion and feeling. Your decision in this case cannot be based on emotion and feeling. You may have strong feelings about the state of the community, the country. You may have had personal, unfortunate experiences. I want you to all understand, again, this process demands people who will promise to make a decision, an important decision, a very important decision, based only on the evidence that they hear about this matter and the law. To do otherwise would be an injustice. I suggest you think about, let's say, your own work, your own job. To do your job, you have to follow certain parameters, and you got to stick to those. You don't make your decisions, most people, in most jobs, based on your emotion or feelings. Same is true here, making these important decisions. So you may feel uncomfortable. You may feel, I've heard a lot going on and it's a very rough time, but that's not this gentleman's burden. And you can't place that on him. All right. So I wanted to put that out there. That's the elephant in this room right now. And think about that. And think about your resolve to do this job. Okay? We have you here to do this job. And that's the response we need to know, putting aside your personal feelings, things you may be experiencing or hearing about, whether you can sit in judgment and make a decision based on, you haven't heard anything, by the way. So is there anyone here who could not look at this gentleman, Mr. Davis, and say, this person is innocent, he's accused? Is there anyone here who is not going to give him that to which it's required. And it's okay to say if you can't. We do have to know that, though. You cannot let emotions and feelings interfere with objective decision making. It's that important. Go ahead, Ms. Dano. You can
So-
follow up with the gentleman.
So going back to you, Mr. Hurtado, can you set aside your personal emotions and feelings and be a fair and impartial juror in this trial?
I don't believe so.
Okay, thank you very much. Now, we are on one side of the spectrum. I want to go to the opposite side of the spectrum, where you think that the law I just read out and the law the judge just read out is silly. It's crazy. Anybody who wants to should have a firearm. Can you please give me your seat number? Because I can't see it number. And what is your name, sir? Oh, yeah, would you?
Alejandro de Mesa.
De Mesa? Okay.
De
I'm sorry.
Mesa.
De Mesa. My last name is Danilo. It's very hard to pronounce, so I understand. De Mesa, go ahead and give me your thoughts.
So my personal opinion is that just because somebody got convicted of a felony at some point in their lives, they made a mistake. I don't feel like they should be barred from carrying a weapon to defend themselves or their family if they feel the need to.
So setting that aside, where I don't want to talk about defending anybody, I just want you to focus on the matter at hand, right? We're going to give you, if you're selected, you're going to be given a set of instructions. The judge has already made it clear that this is just a possession case.
Correct.
Okay? Knowing that and that alone, are you going to be able to set aside your personal opinion and follow the law in this case, even though you don't think it's right?
I believe so.
Okay.
I don't think I could. I mean, I just feel so strongly about it. I don't know if I could be I don't think it would be fair to the prosecution in this case.
Thank you. And that's, ladies and gentlemen, that's what this is all about. You know, there's two parties here. It has to be fair to the defense and to the state.
So just so I'm clear, sir, you may not agree with the law and you're entitled to that, but understand, as I said before, this forum, the judicial branch, jurors' decisions, the law isn't changed here. That goes through the legislature. So understanding that and not minimizing at all your personal feelings about this and your opinion, which absolutely you're entitled to. Question is, are you going to say, I cannot follow the law that the judge is going to instruct me because it is the law that an individual who has been convicted of a felony cannot be in possession of a firearm? That's the law. You may not like it and you disagree with it. Absolutely valid feeling.
Did you want me to respond to that?
I just want to know, yes, whether or not you can say, I will still be able to follow the law because the judge tells me that's the law, I got to follow it.
Yeah, I just, like I said, I just feel so strongly about it
Okay,
that I don't know if I could be fair and objective.
fair enough. And
Yeah.
thank you for your response. Appreciate that. Thank you.
Hi, everybody. I snuck back here. Anybody who shares Mr. De Mesa's point of view that anybody should be able to, I'm coming over here, anybody should be able to have or possess a firearm. Number 34, is that correct? Did I see? I'm running blind here. Miss, what is your name, sir?
First name Jaden, last name Noel.
Noel, Mr. Noel.
Yes, ma'am.
Mr. Noel, can you please explain to us what your thoughts or feelings are in response to Mr. De Mesa?
I also agree with what the previous juror said. I also believe that in life, mistakes will occur. You may get caught up in a situation at the wrong time, and I do believe that even if convicted of a felon, should have the right to hold a firearm in case of any self-defense, if somebody runs inside your house, or to protect yourself in any type of situation.
Okay, Mr. Noel, You heard what the judge said previously, correct?
Yes,
This is
correct.
about a possession case, and
Yes,
I'm
correct.
asking you to set aside any possible facts and theories you could imagine with why somebody would have a firearm. We have to stay on point here that the law is a felon who has been, a person who has been convicted of a felony cannot have or own or be in their possession a firearm. Can you follow that law?
I believe I can follow the law, but I still feel like I'll be biased towards like someone having a firearm, even if convicted. I still feel like I'll be biased towards it
Why would you be biased?
because I feel like everyone should have the right to carry a firearm.
So if we select you for this jury and we gave you the jury instructions, which are not, I'm not hiding the ball, it's in the jury instructions, and you have found that the state has met the elements, right? Convicted felon, knowing, possession of a firearm. You're telling me that you may not be able
Yes, correct.
to make a decision because you are biased.
Yes, correct.
Is there anybody else who, so wait, Mr. Noel, let me follow up with you. So I know it seems crazy that I continue to repeat this question. So are you telling me that you are not going to follow the law? Are you telling me you are going to follow the law? Because you're telling me you're going to be biased, and I'm not exactly sure if that means that you're going to be like, I got to follow the law, or forget this prosecutor, I'm going to do what I want.
Well, by being biased, I kind of mean like I'll probably make like an unfair decision. I'll probably side with like the person like having the firearm. That's what I mean by being biased.
Okay. Is there anybody else who agrees with Mr. Noel? All right. I don't see anybody's hands. And I'm going to just do a quick scan of the room. Okay. Now I want to move on to the next topic, which is knowing. How do we know something, right? If I know something, do I have to say it out loud to mean that I know it? Does anybody know how we can demonstrate knowledge? Does anybody have an example? I'm going to ask you. I don't have your juror number, and 15. And what is your name?
Augusto Leon.
Mr. Leon?
Mm-hmm.
Okay. How do we demonstrate knowledge, Mr. Leon?
We demonstrate knowledge.
I know it's a crazy question.
Mr. Leon,
Leon.
Leon,
Mm-hmm.
seat number 15.
Yes.
All right.
All right, go ahead.
Well, according to the evidence, probably you can gain knowledge or
Okay. Is there anybody know how we can know something? For example, if I were to say, I know I have my cell phone in my hands. Yeah, I know that. But what if I didn't say that? How would you know that I know I have my cell phone in my hands?
Sustain as to the form. You will get a legal instruction on how you determine knowledge based upon the information you receive. Go ahead if you want to rephrase your question, counsel.
Ultimately, do we need to use words to prove that we know something? Or can we do it by our actions? What did you say, ma'am? And I'm going to ask your number 11. And what is your name, miss?
Seat number
Juana
11.
Fernandez.
Seat number 11, Miss
Fernandez.
Fernandez. Okay. Can you please tell everybody what your answer is?
I said both of them.
Both of them.
Yeah.
And how so?
I don't know. Maybe I know something and I can express it with my words,
Okay.
or maybe with my actions. I don't know.
And in fact, you're right on target because the law that I'm going to define for you defines knowingly with actual knowledge and understanding of the facts or the truth. Knowingly means an act done voluntarily and intentionally and not because of mistake or accident or other innocent reason. That's what the law says. Okay, go ahead, counsel.
All right. Thank you very much for proving my point. It can be both, right? And as the judge said, nowhere in there does it say that the person has to say they know something, right? It can be actions, could be demonstration, could be conduct. I'm going to move on to possession now. Unless anybody wants to talk about knowing. They know something that I don't know about knowing. You get that? You laugh, sir. Anybody? Okay. What about possession? Now, again, the judge is going to give her instruction. If I may, Your Honor, do you mind reading the instruction?
I don't mind.
Thank you, Your Honor. I'll have the boss do it. Go ahead.
To prove the defendant possessed a firearm, the state must prove beyond a reasonable doubt that he knew of the existence of the firearm and intentionally exercised control over it. Okay?
Okay. Now, with that definition, does it say that somebody actually has to have something in their hands to be possession? Did you hear any of that? I see jurors number, no, seat, juror seat, jurors in seats. Juror number 18. And what's your name, sir?
Seat number 18, Osvaldo Millet.
Okay. You shook your head in agreement.
Yes, I did.
Okay. So if you're not holding something and you're not manually doing something with it, like I am with this microphone, as you can all hear, like, then how can you possess it?
It could be next to you. It could be someplace else. It doesn't have to be on you or you holding it.
Okay. And thank you very much. And what about you, sir? Juror seat number 20. The judge might throw me out if I say juror number again. Seat number 20.
Repeat the question.
So you were shaking your head, yes.
I'll
Whenever
shake my
we,
head no.
oh, you were shaking your head, no.
Yeah.
Okay, well, I'm glad that we talked. You shook your head. Okay. Can we go to her and then we'll be back to you? I don't want to skip you in line.
I
So
have to continue with the legal definition, continuing on possession. Control, which is part of the definition, can be exercised over a firearm, whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. Control can be established by proof that the defendant had direct personal power to control the firearm or the present ability to direct its control by another.
my apologies, miss. Mademoiselle, seat number 31, go ahead. And what is your name?
Knight, K-N-I-G-H-T.
Okay. So you shook your head in agreement to a question that I posed earlier and that we went to, I'm sorry, sir. Okay, seat number 18. Can you please,
That a person can have possession of
yes.
something. So for me, the best example would be the bailiffs that are walking around with the mic in their pocket.
Yes.
So they didn't have, sometimes they don't have it in their hand like right now, but they're in possession of it, even if they're not touching it in their pocket or.
Okay.
Yeah.
What if they set it down next to the seat?
I would not consider
Sustain,
that
no,
being their
no,
possession.
counsel. I'm going to sustain the objection as pre-trying. Continue, please.
Yes, Your Honor.
I would not consider that possession.
Yeah, I'm going to move on. But I think that that's a good example, right? That you just pointed out to everybody. Okay. Mr. And I appreciate you and very much for bringing that to everyone's attention. What about juror number 20, and what is or seat number 20 and seat number 20, and what's your name?
Sheldon Reels.
Mr. Reels?
Yes.
Okay. Go ahead. You said you shook your head in disagreement because you think opposite, that you need to have physical possession?
Well,
No, I put you on the spot.
All right. Yeah, again, I read you ultimately at the end of the case, you will get the law as how you make these determinations. Okay. On how the state must, in order to prove the elements of the crime that's charged. Again, the two elements that the defendant had been a convicted felon, and second, after the conviction, the defendant knowingly owned or had in his care, custody, possession, or control a firearm. And I gave you, I'm not going to go through all of the instructions again, but I explained to you how the law defines possession and what control means. So the question really at this point that we need to know is, will you follow the law as given?
You're shaking your head. Yes.
I'm sorry, what's your name, sir?
Seat number 20.
Sheldon Reels.
All right, thank you, sir.
Okay, and you indicated you would be able to follow the law.
Yes, but can you, I don't need to make you repeat, but could you repeat the definition of possession by the law for?
Judge, does anybody have any objection to that? I do not. If
No, go ahead. I mean, it's hard to hear what the question was, so why don't you repeat it?
Oh.
I'm not hearing the question.
No, he's asking you to repeat the instructions regarding
Well, it's
possession.
only part of the instructions, sir. All right, but I'll repeat again what part of the definitions of the instruction and the elements of the crime. To prove the defendant possessed a firearm, the state must prove beyond a reasonable doubt that he knew of the existence of the firearm and intentionally exercised control over it. Control can be exercised over a firearm, whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. Control can be established by proof that the defendant had direct personal power to control the firearm or the present ability to direct its control by another. Okay? Does that clarify more for you? That's Mr. Rios, right?
Yes, yes.
All right.
That's it.
Very good. Thank you, sir. Go ahead, counsel.
I wanted to just do a brief hypothetical about possession and control. I have a golden retriever. He's about 75 pounds. Sometimes I walk him with a leash. Sometimes I don't. Oftentimes, would you all agree I have control over him when I'm walking him on the leash, right? I'm holding him. I see heads nodding. I don't see anybody disagreeing, unless you have a very BAD dog at home and you don't have control of him when he's on the leash. But my boy's good. Sometimes I take him off the leash. I know that could be an ordinance violation, but let's set that aside, right? I take him off the leash. And he's walking next to me, right? He moves a little bit further and I go, sorry if that bothered anybody. Have I exercised control over him? Can we say yes?
Overruled.
Did I use my hands? No. 32.
Seat number 32, Mr. Lee?
Mr. Lee. Thank you, Mr. Lee. You can shout it? I think, did I exercise control over my dog?
Yes, you did.
Did I pull his leash?
No, you did not in this situation.
Okay. How did I do it?
You exercise control verbally with a whistle.
Okay. What if I went like, and he follows that command? Did I exercise control over him without
Yes, you
using
did.
my voice?
Yes, you did.
Okay. Can everyone understand that? That controlling something doesn't always have to be physical. Does anybody disagree with that?
There's a young lady in
Oh.
the back, and is that seat number 39?
I like the hustle to run over the hustle. I do. I like the
Let's
hustle.
see, who is that, please? What seat number, name?
My name is Lisa Pocklock.
And what is your seat number?
Okay,
I don't have a seat number.
okay, Ms. Lock,
Jury
okay,
number is 51.
okay, go ahead.
So I find that example not a great example.
Okay.
I don't see how that can be compared to, a living being compared to a machine that is not able to move on its own. So I don't think it's a very good example.
And well, let me say this to the juror and to all of you. Question remains. I've read you the law. You're going to have a copy of the law. Will you follow the law as described to you?
Yes, I have no problem following the law.
All right. Thank
Okay.
you, madam.
And it's not that I don't want to talk with you more. I'm sorry. Yes, the judge has already made her confirmation, but I appreciate your feedback and what you said. It was more just a demonstration of control than anything, okay? Because I can't get into the facts of this case. You have very limited knowledge of the facts of this case. I can only talk about, words and issues and matters and meanings. But so we do our best here.
We don't talk about the facts of the case in the jury selection because that might lend itself to jurors prejudging and starting to formulate opinions about the merits of the case. And one of the things that you cannot do is to form opinions or start thinking about your conclusions until you have heard all of the evidence, the argument of lawyers and the law. You cannot prejudge. So that's a restriction that is critical, that we don't discuss any facts of the case. Okay, thank you.
All right. So we've talked about the two major, two of the elements, right? I'm not going to get into the first element, which is proving the defendant is a convicted felon, because that's going to come later. But two of the very important elements, which is knowledge and possession. Is there anybody here who does not understand anything that we have just talked about? They are completely lost. You think to yourself, I don't know how I'm going to do this. Is there anybody who's completely overwhelmed by the thought of having to hear the facts, make a determination? Hi. What's your seat number?
I'm sorry, I cannot hear.
Seat number 30.
And what's your name, miss?
Mamie Hurt.
Hurt? Miss Hurt. Just what I said, and we made eye contact. Are you comfortable with doing that?
Yes.
Do you think that you can listen to the facts, review the elements, and make a determination?
Yes.
Okay. Is there anybody else who thinks that that job is too tough? Sir? What's your seat number?
27.
27?
Arturo Cepero.
What about you? Do you think that you can do this job fair and impartially? Man, how about you? How are you doing? 22. Is there seat number 22? And what's your name?
Ina Sheridan.
Okay. Is there anything that we talked about today? Possession, knowing. Any questions about that?
No.
Okay. And if you were able to hear the facts of this case and we gave you the instructions and the law, you would be able to follow them fairly and impartially. Okay. Thank you very much. All right, then. I really appreciate your time. I thank you for your attention. I'm sorry if there was some confusion with the juror number and the seat number. That was my fault. I look forward to seeing you all again. Thank you.
All right.
Oh, yes, Judge, we have just one more
Oh,
person.
we have a young lady. Is that Ms. Connor? Is that, I'm sorry. I'm
Seat
sorry.
number 8, Ms.
Okay.
Connor.
Yeah, let's get the microphone on you. There you go.
I'm Vivian Connor.
Ms. Connor, yes,
Yes,
ma'am.
I don't know when I'm supposed to say this, but I am on full paid vacation from my job this week.
You are on what?
I'm on vacation.
This is the great way to spend vacation. How exciting. Summer vacation.
Such a vacation.
You know, you should speak with your employer again because you're required to be here. So perhaps you can get back the day or 2 days you're selected on the jury as part of your vacation. This is required by law. You get a subpoena. You're instructed. You must come to the courthouse.
Well, I told him I have, that I have to come here, but he said, I know he's not gonna give me this.
Oh, I don't
2 day
know.
vacation
What kind of
for-
business is it? Is it a large business?
I'm sorry?
What kind, where do you work?
Macy's.
You work at Macy's.
Yes.
And this is vacation for you?
I'm sorry?
Well, I think, what do you do? Are you a full-time employee there?
I am full-time employee. I work for Big Ticket.
Why don't you have your employer give me a call?
Because, yeah, I told him, if they can. change
Yeah,
my
well,
days, so I can-
you're required to be here by law. So perhaps it shouldn't cut into your vacation. And there's certainly more than 10, 15 people that work at Macy's. It's a pretty big company. Yeah. So if he has any question about it, I would go back, maybe talk to someone else, maybe above him, maybe above the direct supervisor. But besides all that, this is a fabulous way to spend vacation. All right. Thank you. Anyone else have any comment? Okay. Is everyone doing okay, or do you need a 5-minute stretch? You need a 5-minute stretch and restroom. That's what we're going to do. Listen to me before you start moving, please. Don't talk about anything you heard about this case. We're going to take, there's restrooms outside as well. We're going to take about 5 minutes, though. We're going to do it quickly because I want to get the defense on front of you, and I would like to get you all out of here no later than noontime or 12:30 the latest, okay? So you can complete the work today, and some of you, again, will come back tomorrow, continue with the case. So we'll make it 5 minutes. Don't talk about the case. Thank you. All right. All right, ladies and gentlemen, everyone appears to be back. Again, I had indicated if you wanted to have some water or coffee or something at your seat, that's fine, but please pay attention to the attorneys. Don't get distracted and don't make a mess, okay? All right. Now defense will speak with all of you for a little bit. Give counsel the same attention given to the state. Thank you for the defense. Make sure to take the mic with you. Good.
Good morning, everyone. So I want to start off with a simple but very important question, all right? Who here remembers my client's name? By show of hands. Okay, I see a hand right up here in the front, and that's juror seat number 4, Miss Beckford.
That's why you bet for seat 4.
Yes, what is my client's name?
Tavares.
Tavares, okay.
Davis.
You got the last name right. So his first name is Terrence and his last name is Davis. Thank you so much, Ms. Beckford. The reason why I start off by asking that simple but important question is because if you are selected as a member of this jury, you're going to hear Mr. Davis called a lot of names. You're going to hear him called the defendant, the suspect, the perpetrator. But Mr. Davis is a human being, and I want to make sure that if you're selected on this panel, we all remember that fact, all right? So I want to start off by going back to something the judge said in the beginning of this jury selection, and that was the rules of the house, all right? We all want to make sure that you acknowledge that the way that we do things in the courthouse is very different than how we do things in our day-to-day lives. And throughout this process, while I'm asking you questions, I'll be making comparisons to how we do things in the courtroom versus how we might handle things in our day-to-day lives. So I want to start off by giving you an example of how things are different here than when we are not in the courthouse, all right? Who has been driving by a highway, and on the side of the highway, you see a police vehicle pulled over, and you have someone sitting in the backseat of the car? Show of hands, who's seen that? Okay, let's see. I see a hand.
The gentleman here with the purple shirt,
Yes, if you give me your juror number and your name, please.
that's you.
Sorry, seat number.
Seat number 18, Osvaldo Millet.
Mr. Millet, seat number 18. Okay.
All right, Mr. Millet, has that been a situation that you've seen or
I have seen
experienced?
it. Yes, I have seen it.
So tell me, Mr. Millet, what was the first feeling? Like, what came to mind? What was your thought process when you saw it?
Well, I look at it as they're trying to protect a person, first of all, if you're on a highway.
Yeah.
So you're not going to keep him outside to put him inside. That doesn't mean he's guilty or not happen. So
Okay.
that's the way I would see it.
Okay, that's great, Mr. Millet. Thank you so much. I appreciate your answer. I think the female right behind you with the black shirt, did you also raise your hand? If you could give me your seat number and your name.
23, Linda Alonso.
Seat number 23.
All
That's
right.
Miss
Linda Alonso.
Alonso.
All right, Ms. Alonso, when you saw that person sitting in the backseat of that police car, what was your gut feeling? What did you think?
Well, I just thought, wonder what he did.
I wonder what he did, right? That's our gut feeling. Mr. Millet says, you know what? I'm not going to make any presumptions, but a lot of other people will pass by that car and say, man, why is that guy in the back of that police vehicle, right? Those are our natural gut feelings when we see those types of situations. However, when we're here in the courthouse, it's a completely different thing. So I know that Ms. Alonso told us my gut feeling is to think, I wonder what he did. But if we stop and we think, Ms. Alonso, can you think of a reason why an innocent person would be sitting in the back of a police vehicle?
Well, it could be a person that was missing and they found them. Or,
Okay,
you
so
know,
I just want to make sure we can hear you because it's really hard to hear you. Speak real loud into the microphone. You
no,
said
just
someone
said
could
it
be
a
missing.
person that was missing and they
Okay.
have them in the back waiting for somebody to come and,
Okay.
you know, retrieve them, or, you know, or they're giving a ride to somebody that was walking on the side of the road.
Right.
Work for the highway patrol, so it happens.
Oh,
all the time.
okay. So,
Yeah.
you know, so you have some reasons, of course, other than what might be an instinctual first thought of what did that person
Yeah,
do?
right.
Okay. Fair enough.
So those are great examples, Ms. Alonso. We stop and think we can all come up with different reasons. Maybe someone's victim of a crime, maybe someone's getting a ride, maybe someone was missing and was found, like Ms. Alonso pointed out. There are various reasons, innocent reasons, why a person can be in the back of a police vehicle. So we come into the courthouse, we got to put those sort of gut reactions of, man, I wonder what he did. I wonder what he did to put himself in this position, right? And that comes to the presumption of innocence. Everyone here needs to assure me that you can either presume or believe that Mr. Davis is innocent as he sits here before you today. All right. So I want to talk to a few of you and make sure that this is something that you're all comfortable with following this case. So if I could start here to my left with juror seat number 1, Ms. Acosta. Ms. Acosta, do you believe that because Ms. Davis is sitting here between two defense lawyers, that he must have done something wrong?
Yes.
Yes?
Yeah.
You understand that Mr. Davis has the presumption of innocence and that you are to believe or presume that he is innocent of any crime that the state is accusing him here.
Yes, that's the law.
Okay, but you're telling me that although you understand the law, you still feel that you would bring those gut feelings from the outside of the courtroom into the courtroom, and that you believe that because Mr. Davis is here between two defense lawyers, that he must have done something wrong.
So you are unable to give him the presumption of innocence, understanding that that is the law, and we are here because this is the only forum that there is to have the government prove an accusation against a citizen. He is innocent. The Constitution says any citizen accused of a crime is innocent unless the state can prove guilt. This is the only place that there is in a trial to provide the opportunity and the forum for the state to meet their responsibilities under the law.
I understand.
Okay, so are you telling us that you cannot follow the law and sit here and presume that Mr. Davis is sitting here and he's innocent? He hasn't done anything. You haven't heard any evidence.
Yes, I understand. I think it all depends on the evidence.
You what? I'm sorry?
It all depends on the evidence.
All right.
If he's
Are you having
possibly-
difficulty maybe understanding the question?
Can you repeat the question?
Okay.
One more time?
Mr. Davis sits here. He's accused of a crime. You have heard no evidence at all that any crime was committed, let alone that Mr. Davis committed any crime. Okay? If you had to understand that he is innocent, if you had to make a decision now,
He's innocent.
okay, he's innocent. If you were asked to make a decision, guilty or not guilty, what would that decision be as you sit here now?
Well, I don't think I could make the decision without having like any evidence. But
Well,
right now,
no,
with
the
no
decision,
evidence-
that's where I have to clarify, and I want to know if you understand that and can follow the law. If you had to make a decision, anyone now, as to whether or not Mr. Davis is guilty of the crime he's accused of or not guilty, what's the decision? Does anyone want to volunteer? Young lady here, which is seat number 11.
Right now, he's innocent.
He's not guilty.
Yeah.
Yeah. There's two choices, not guilty or guilty at the end of the case. He's presumed innocent, therefore he's not guilty. Does anyone disagree with that or have a concern about their ability to look at the gentleman and say, he's not guilty of anything, he's innocent? Anyone raise your hand if you want to discuss that. So Ms. Acosta, can you say that he is not guilty?
Yes. He's not guilty.
I'm sorry, your voice is
He's
very.
not guilty.
Okay, but do you believe that?
Like I said, I need to know the facts of the case. I know I'm not allowed to know the facts of the case right now.
Did you look up the facts of this case?
No,
Do you know anything about the facts of this case?
no,
So, and you have no evidence, right?
no.
So,
Fine.
are you clear that you can follow the law?
Yes.
All right, counsel, why don't you go ahead?
Thank you, Your Honor.
Thank
Okay.
you, ma'am.
And if I can speak to the juror right behind you, that number three, thank you so much.
Seat number 3, Mr. Barrio.
Yes.
Mr. Barrios, similar question to you. Do you believe that because Mr. Davis was arrested in this case, that he must have done something wrong?
If you would have asked me that this morning, probably, but after hearing the way the judge has spoken, she's right, innocent to proven guilty.
Okay, and let me ask you this follow-up question. Do you feel that not just that Mr. Davis was arrested, but that now he's here in a trial procedure, sitting between two defense lawyers? Does that change your mind and make you think he might have done something wrong?
Similar, and like now I'm open to him being innocent first, but usually when I see a defendant, I probably think to myself, what did they do?
Okay, then that's fair. Remember, we have those gut reactions
Yeah.
outside of the courtroom. And I just want to make sure that the procedure that we're supposed to follow in the courtroom is something that you're comfortable with
Yes,
doing.
it
That
is.
is?
Right. And again, experiences, what you think, you see things on television, your own personal opinions, but you've never served on a jury before. Is this the first time for you?
First time.
It's a new experience for most of you. So that's why going through the explanation, even though it takes time to explain the job description and the blueprint for you to follow, we need to know if you believe in your heart of hearts that you have the ability to follow these rules while doing the job here. What you do outside this courthouse, you have your own rules.
I do.
You
I
feel
can.
comfortable with
Yeah.
that? All right. Thank you, sir.
So, Mr. Barrios, just one last question for you. If you had to return a verdict right now, having heard no evidence in the case, what would your verdict be?
It would have to be not guilty, but it just feels weird giving a verdict on something I have no
Right.
information about.
It's an odd question because a lot of people think, well, I haven't heard anything. How can I give you a decision? Well, we're pressing you because of the point of the presumption of innocence, basically. And that's the reason why we press on this. Because it seems a little illogical, but understand your point.
Yeah.
Thank you, sir.
Thank you, Mr. Barrios. All right, and if I can, jersey number 9? Oh, right.
Seat number 9, this is Mr. Corrado.
Yes,
Corrado,
Yes.
excuse me.
How you doing today, Mr. Corrado?
well.
Mr. Corrado, similar question to you. Do you believe that because Mr. Davis was arrested, he must have done something wrong?
No, yeah, same point. He's innocent on proven guilty. So at this point, he hasn't done anything wrong.
Okay, and what about the fact that he's not only got arrested, but that now he's in trial, sitting between two defense lawyers? Does that change your mind and make you think now he really must have
Not
done
at all.
something wrong?
Until evidence is proven and stuff like that, he is still innocent.
Okay, thank you very much. All right, does anybody disagree with Mr. Corrado and think, you know what? I understand the presumption of innocence, Ms. Zamora. I understand what the law is. However, the fact that you're telling me that not only he got arrested, but the fact that he's here facing trial makes me believe that he must have done something wrong. Show of hands, anybody here feel that way? And I'm gonna check over here, make sure I'm not missing any hands. Okay, all right. So I want to move on to the charge that Mr. Davis is facing here today, all right? You heard the judge tell you that the charge is felon in possession of a firearm. And then you heard the prosecutor in the case explain to you that there are 2 elements or 2 requirements in order to prove that charge. And the first of that is whether or not Mr. Davis has been convicted of a felony. I am going to tell you right now that the defense is doing a stipulation. We are agreeing ahead of time to the fact that Mr. Davis is in fact a convicted felon. So I want to talk to you about each and every one of you to make sure how you feel about that and what your opinions are now, knowing that Mr. Davis is in fact a convicted felon, right?
Now, and if you don't mind, let me jump in also. When we talk about parts of a crime, elements we call them. In this case, again, the accusation is a convicted felon being in possession of a firearm. There are two parts to that. Think of baking a cake. You have to have parts in order to get that cake. Okay? You must have, for that cake, you do it with a mix, like me. You got to have the mix. You got to have the eggs. You got to have milk or water. Let's just go with that. Okay? If you don't have those eggs, what will result? You're not going to have the cake. Well, you might have something, but it's not going to go very far. Okay? So, similarly, as an analogy, this crime requires the state to establish two elements. One is that the individual accused has been previously convicted of a felony, and two, that the individual, read it again, after the conviction, owned or had in his care, custody, possession, or control a firearm. Okay? Counsel has just indicated that the parties are going to agree that that first part, that first element is being agreed to. Okay? She's going to ask you some questions about that. Okay? So it's not something, an element that the state is going to have to prove because the defense agrees to that. Okay, very well. Go ahead, counsel.
Thank you, Your Honor. All right, juror here with the burgundy pants. I'm sorry.
36.
36. Miss Texidor?
Perez Texidor.
Perez Texidor. How you doing today?
Fine, and you?
I'm doing well. All right. So I have two questions for you, Miss Perez Texidor. Now knowing that Mr. Davis is in fact a convicted felon, do you believe that a convicted felon is more likely to commit a crime?
Yes.
You do? Tell me about that.
It's just a gut.
Gut feeling. Okay. I will tell you that the law says that because you are supposed to presume Mr. Davis innocent, you are not supposed to believe that because he did something in the past makes it more likely that he is going to do something in the future. Now,
I
okay.
do understand that, and I do understand the law.
Okay. So I guess my question to you is knowing that you are not supposed to believe that because he did something in the past makes it more likely that he's doing something now. Is that something that you can promise me you are not going to do if you are selected as a juror?
In other words, you're not going to hold it against him.
That I can say. I'm not gonna hold.
You're
that
not going to
against-
hold it against him because
This is a
there's
different
already
thing,
an
and I have to-
agreement
Yep.
that the gentleman in the past was convicted of a felony, that this is a crime that requires proof of those two elements. And that prior situation, the law says cannot influence you to make any presumption about what happened in this matter.
I understand that.
Okay, I know you understand it. Can you follow that law?
Yes.
Okay. All right.
Thank you, Ms.
Thank you,
Perez
madam.
Texador. And sitting over here to your right-hand side, juror number seat 16.
16, my name is Albert Lyons.
How you doing today, Mr. Lyons?
Just fine, thank you.
Mr. Lyons, same question to you. Do you believe, now knowing, because I've told you, that Mr. Davis is in fact a convicted felon, do you believe that that makes it more likely that because you committed a crime in the past, that you're going to commit a crime in the future?
No, I don't.
No? Okay, and tell me about that.
Well, like a gentleman said earlier, people make mistakes and you can't hold them, their future accountable for a mistake they made in the past, whatever those circumstances were.
Okay, thank you so much, Mr. Lyons. And behind Ms. Perez Texador, if you could give me your juror seat and name, please. I'm sorry.
21, Aaron Rodriguez.
Okay, how you doing today, Ms. Rodriguez? Good. Ms. Rodriguez, same question to you. Now knowing that Mr. Davis has been previously convicted of a felony case, do you feel that that makes it more likely that he is guilty of this crime or more likely that he would commit any other offense?
No.
Tell me about that.
Like that was something that has happened in the past, and I think there's room for growth, whether it was a year ago or who knows how many years ago. That was something that has happened, but that was then and this is now.
Okay, and do you feel that that is that because he's been convicted of a felony in the past, you think it makes it more likely that he would own or possess a firearm now? Do you think that's something that would be more likely?
No.
Okay, thank you so much.
I'm sorry, which juror was that?
Rodriguez, juror seat number 21, Your Honor.
Thank you very much.
Okay, I'm just gonna go a little bit back here. Hello? I'm sorry, with this, I hadn't been able to see you until
That's
just.
fine.
All right, and this is juror seat number 25.
Alejandro Batista.
How you doing today, Mr. Batista?
Good, and yourself?
I'm fine. Same question to you, Mr. Batista. Do you believe, now knowing that Mr. Davis is in fact a convicted felon, do you believe that it makes it more likely that he would commit a crime in the future or more likely that he committed this crime that he's accused of here today?
No.
Can you tell me about that?
It's like the gentleman said, if you did something in the past, that doesn't mean that you're gonna do the same thing or something else now or in the future. So, no, I don't believe that he would do something or that it should take matter into this situation.
I'm sorry, and again, that is the gentleman in seat 25. 25?
Batista.
Okay.
Thank you so much, Mr. Batista. All right, so on this same issue of being a convicted felon, I want to let everyone know now that as part of this trial, you are not going to find out what the crime that Mr. Davis was convicted of as a felony, what it was. You're not going to hear what that conviction was for. So you will not know if it was for a major felony. You will not know if it was for a minor felony.
All right. Counsel, sustain. Ladies and gentlemen, let me explain to you. The element of the crime is that there's a prior conviction for a felony, period. And that is being agreed to by the parties. Thank you. Go ahead, counsel.
There's a hand right here. I'm sorry.
Oh, young lady here, this is Miss Cole. Okay, seat number 7.
Yes. Can you explain what a minor felony is?
That's
compared
why
to
I
a-
cut, that's why I cut in, madam. There's no such thing as a major or minor.
Oh,
Has
but
nothing
that's
to
what
do
you
with
said.
anything. A felony is a felony. It's counsel. It's an improper question. It has no relevance whatsoever. Convicted felon, doesn't matter.
Oh,
Whatever.
I thought that's what I heard from you.
I didn't say that.
No, she's asking to disregard that question.
I'm not telling you to disregard anything counsel said, because there's no such thing as minor or major or serious, not serious. A felony crime is a felony crime. The whole issue here is, to be clear, I think council was trying to say, it does not matter whatever that was, and you're not going to hear anything about it because it has no relevance.
Thank you, Your Honor.
All right, move along, council.
It was phrased a lot better by the court than myself. Okay, so I just need to be sure that because it doesn't matter what the felony was, that's not going to be something that you're going to be thinking about during your deliberations. Okay?
Council, would you come here, please?
Yes, Your Honor.
We're going to have a sidebar. Give us a moment. All right. Sorry, ladies and gentlemen, for the interruption. All right, council?
Yes, thank you, Your Honor. Okay, so I'm gonna make my way back here. I haven't seen any of these faces. Sorry, my view is very low. Okay, so gentleman over here in the black leather jacket, if you could give us your jury seat number.
I think 42.
42.
What's the gentleman's name?
Zephyr, Lucian Zephyr.
Lucian Zephyr. How you doing today, Mr. Zephyr?
Good, good.
Mr. Zephyr, do you believe, now knowing that Mr. Davis is a convicted felon, do you believe that makes it more likely that he committed the crime here today?
No.
No? Okay. Tell me about that.
I mean, just from hearing like what you guys said before, like he's innocent till proven guilty, and plus just because somebody had like a past history doesn't make it like they'll repeat it again.
Okay.
So if I was to think that, it would just be me assuming.
Okay. Thank you so much. And right behind you,
Dade Anthony Pope.
your seat number 38. How you doing, Mr. Pope? Mr. Pope, same question to you. Now, knowing that Mr. Davis is, we are agreeing to the fact that Mr. Davis is a convicted felon. Do you believe that that makes it more likely that he committed this crime or that he would commit a crime?
No, that's pass.
Okay. Thank you so much, Mr. Pope. Right here in the pink blouse.
39, Marcia Robotham.
Thank you, Mr. Robotham. How you doing today?
Good.
Similar question to you. Do you believe that because someone is a convicted felon makes it more likely that they would possess a firearm?
No.
No. And do you believe it's more likely that they would commit a crime in the future because they committed a crime in the past?
No.
Oh, okay. Thank you so much. And right behind you,
I think seat 40, Lazarus Suarez.
yeah, that's what I have here. Jersey number 4. How are you doing today, Mr. Suarez?
Good, and you?
Good. All right. So similar question to you. Do you believe that because Mr. Davis has been convicted in the past makes it more likely that he committed the crime that he's charged with here today?
No, I think that since it was in the past, he could be the change could be different personnel. So I don't think it'll make it more likely.
Okay. Thank you very much. Miss Jersey number 37.
Yes, Lisa Parker.
Thank you. I get happy when I actually match the seat with my shirt. How you doing today? Same question for you. Do you feel that it is more likely that Mr. Davis committed this crime or would commit a crime because of the fact that he's been convicted of felony in the past?
No, I don't.
Okay, thank you so much. And right in front of you, hi, is that 21?
Marisol,
Oh, no. Oh, sorry, they
35.
Miss Pardo. Yes, I know that they moved you to the side. How you doing, Miss
Good,
Pardo?
how are you? Yes.
Same question for you.
I tend to just, I think that if you had a run-in with the law, you should know better than to do something that you know is going to cause you more trouble.
Okay.
I haven't seen the defendant. I don't know what he looks like, so it's just my opinion.
Okay, thank you so much, Ms.
You're
Pardo. And then right next to you in the corner, if you give us your
Yeah.
jersey.
58. Sandra Turo.
Okay, I think your jersey is 41.
Oh, I'm sorry.
That's
yeah.
okay, that's okay. Same question for you.
So yeah, I think they can get a second chance, and we just have to hear the facts.
Okay, thank you so much.
Counsel, I'm sorry to interrupt you. Can you come up? I just have to ask you a quick question. I don't need the. Emil?
All right, so I just want to open up this question now to everyone. Is there anyone here by a show of hand that believes, you know what, Ms. Amora, if someone has been convicted of a crime in the past, especially because you told me that you are agreeing to that fact, it makes it for me more likely that he committed this crime or that he would commit a crime? Show of hands. Anyone feel that way? Okay, and for the record, I see no hands. All right, so I want to talk to you. I know we've been discussing a lot about the jury instructions, but specifically, I want to talk about one portion of the jury instruction. The jury instruction reads, a portion of it, that mere proximity does not establish that a person intentionally exercised control over the weapon in the absence of additional evidence. That means just because something is next to you doesn't necessarily mean that you are aware of it or have established control over it. So I want to ask you if there's anyone here that would automatically believe that just because something is next to you, that means that you automatically know about it and can automatically establish control over it. And I'm gonna start here in the middle with juror seat number
11.
11, Ms. Fernandez Ramirez. How you doing?
Fine.
All right. Would you automatically believe that because something is next to a person, that means automatically that the person knew about it and can exercise control over it?
No, I don't believe so.
Okay, perfect. Thank you so much. And then here in the front with juror number 4, Ms. Beckford. What about you? Well, do you automatically believe that because something is next to a person, mere proximity, that means that they can automatically establish that knowledge or aware that it's there and control over it?
No,
Tell me about that.
because just because it's bottom or next to them, I don't mean they know, because they could have just got there not paying attention or.
Okay, thank you so much. And then right next to Ms. Beckford, we have Mr. Cabrera, juror seat number 5.
Good morning.
Good morning. How you doing, Mr.
Good.
Cabrera? Same question for you. Do you would you believe just because an item is next to a person, mere proximity, that would automatically mean that the person has knowledge of it and control over it?
Yes.
Yes, just because it's next to you.
Mhm.
Okay, explain that to me.
In case he might need to use it and he knows that he has it right next to him, so he has possession of it.
No, but Mr. Cabrera, think the question is this, and the instruction reads, the law says, back to it. The law says mere proximity, that means just being close to an item, does not establish that the person intentionally exercised control over it in the absence of additional evidence. That's what the law says. It does not establish an intentional control over an item just because it's there.
Okay.
There has to be more evidence presented.
Okay.
An item sitting someplace next to someone, mere proximity is not sufficient on its own to prove control. There must be additional evidence. Do you understand that that is the law?
Yes, now I do.
Okay. Now, you had responded before that mere proximity, you means that the person has control. You understand, though, the law says otherwise. There has to be additional evidence. Are you able to follow the law?
Yes, now.
You understand the
Yes.
difference? I was trying
Yes.
to explain it. Okay, very good. Thank you, sir.
Thank you, Your Honor. And if I can ask the same question to juror seat number 6, Mr. Cesarano. Thank you so much. I didn't want to butcher that. How you doing today,
I'm
Mr.
good, thank
Cesarano? Same question to you. Would you automatically believe that just because something is next to you,
No.
meaning mere proximity? Okay, tell me about that.
No is no.
No is no. Okay. Would you believe could you be able to follow the law that you would require additional evidence in order to prove control over that item?
You need to have evidence.
Okay, thank you so much. All right, so I want to move on to actually, let me open it up to everybody. Does everybody understand what the law is by meaning mere proximity? I see a thumbs up in the back. Mere proximity, just because something's next to you. I see shaking heads. All right, perfect. So I want to move on now to the burden of proof in the case, which goes hand in hand with the right not to testify in this case, okay? So the burden of proof, as the judge explains it, lies solely on that table over there. Mr. Brody and I, as the defense, we don't have a burden. We can sit here, play cards, be on our phones, send text messages, not look up, not question a single witness. And we would not have to. The law does not require us to prove a single thing. So again, the way that we address things in our everyday lives outside, we would want to hear both sides, right? We would want to hear what does one party say their version of events is compared to the other side.
And by the way, that's a civil case. That's what happens in a civil case. Okay, you have two parties and there's a dispute over something and you get evidence from both sides, both parties. It's a criminal matter. Constitution jumps in right there to make sure that these rules are followed. They're very different. Go ahead.
Thank you. So here in the courtroom, you are only required to hear from one party. And I want to make sure that that's something that you are comfortable with following in this case, because it is different from what we do in our regular day lives. So sitting behind Miss jersey number 12, Miss Gonzalez. How you doing, Miss Gonzalez? All right, Miss Gonzalez, would you feel comfortable reaching a decision in this case, reaching a verdict in this case, not having heard at all from either Mr. Brody or myself, or do you feel that you would have to hear from both sides?
No, not necessarily.
Okay, explain to me what you mean.
Well, because the state has to prove if they're guilty or not.
Okay, so you would feel comfortable if Mr. Brody doesn't ask any questions, if I don't ask any questions, that you would feel comfortable holding the state to their burden and making sure that they provide proof beyond and to the exclusion of every single reasonable doubt.
Right.
Yes, okay, thank you so much. And right next to Gonzalez is juror seat number 13, also Miss Gonzalez, Jolene Gonzalez.
Okay, so I need, this is Miss Jolene Gonzalez.
Yes,
Okay.
Jolene.
How you doing today?
I'm good. How are you?
Oh, good. Would you feel comfortable reaching a decision in this case? If you did not hear Mr. Brody or myself ask the jurors any questions or engage in the trial in any way?
Yeah, I'm comfortable with it.
Okay, let me follow up with this question. Not only do you not hear from Mr. Brody or myself as the lawyers, but Mr. Davis chooses to exercise his fundamental right not to testify. Would that be something that you would consider in your deliberations, the fact that not only did you not hear from the lawyers, you also didn't hear from Mr. Davis?
I'm okay with it because it's his right to remain silent. So
Okay, thank you so much, Ms. Gonzalez. Juror seat number 17, Mr. Flores.
How about you, Flores?
How you doing, Mr. Flores?
Hi, good.
Mr. Flores, same question for you. Would you feel comfortable reaching a decision in this case, deliberating in this case, if you did not hear Mr. Brody or myself ask any questions throughout this trial?
No, I will not.
Okay, would you require to hear some evidence from the defense in order to reach a decision?
Yes,
And you understand that the law requires that, or the law states that the defense has no burden and that we have no requirement, not the lawyers or Mr. Davis. You understand that? Yes? Can you say that?
Can I,
yeah, but how can I reach a decision without hearing from
okay, so,
question from you or
right,
just
so,
from them?
and let me jump in there, Mr. Flores. To sit as a juror in a criminal case, it's the state's responsibility, completely and solely, to prove that a crime was committed and the person accused committed the crime. There is no responsibility whatsoever in a criminal case for the defense to do anything. So let me give you this example. Let's say you were on the jury and at the end of the case, you have heard all the evidence. I gave you the law and you're in the jury room and you're thinking, well, there was some evidence, but the state has not proven beyond every reasonable doubt that Mr. Davis committed this crime. Okay, I'm giving you that. That's your conclusion, that they have failed to prove beyond every reasonable doubt that Mr. Davis committed the crime. Are you going to then say, well, because Mr. Davis didn't testify and they didn't present any evidence, I'm still going to find him guilty? You understand the question?
Yes.
Okay. So that's the concern. Because if the state does not meet their responsibility of presenting sufficient evidence beyond every reasonable doubt, the verdict, your decision, must be not guilty,
Understand?
period.
Yeah.
Whether they put on witness, whether Mr. Davis testifies or doesn't testify, it's a non-issue. If they don't meet their burden, case is over. You must return that verdict. Is that going to be a problem for you?
No, we won't.
Yeah,
I understand.
because it's different than what you had said a little while ago. So I want to make sure, because you said, well, how can I sit here if I don't hear from them and I don't hear from them? That's not the type of case this is. This is a criminal case.
Okay.
You were in a different courthouse in a civil case to be different. This is a criminal case where the entire responsibility of presenting evidence and proving guilt beyond every reasonable doubt is with the state. Are you clear now?
Yes, I am.
Okay, all right.
All right, so Mr. Flores, would you feel comfortable reaching a decision if in fact you do not hear the lawyers from the defense asking any questions?
Now that I'm clear, yeah.
Okay,
Yeah.
and would you feel comfortable as well if Mr. Davis decides to exercise his fundamental right not to testify?
Yes.
Okay, thank you so much. And then right behind you,
22.
22, thank you so much, Ms. Sheridan.
Sheridan. Yeah.
How you doing, Ms. Sheridan? Ms. Sheridan, same question for you. Would you feel comfortable reaching a verdict in this case if Mr. Brody and myself don't ask any questions of any witnesses in this case?
Yes, I'll feel comfortable.
Okay, and what if Mr. Davis decides to exercise his fundamental right not to testify? Would that be something that you would consider or hold against him if you're selected as a juror in this case?
No.
No, and I saw you hesitate a little bit when you said no.
I'm trying to understand that question. So
Yeah,
before I answer,
I'll rephrase it.
Yeah.
If Mr. Davis decides that he does not wish to testify in this case, as is his right, would that be something that you would consider or hold against him if you're selected as a juror? In
No.
this case? Okay, thank you so much. Juror seat number 28, Mr. Cotto. How you doing, Mr. Cotto? Mr. Cotto, same question for you. Would that be something that you would consider?
What?
I'll
Sorry.
repeat the question.
Sure.
If Mr. Brody and myself don't ask any questions in this
okay.
case,
Yeah.
would that be something that you would consider if you're selected as a juror in this case?
No, it wouldn't.
Okay, and what if Mr. Davis decides not to testify? Do you feel that that's something that you would consider or that would cross your mind if you're selected as a juror in this case?
No.
No? Okay, thank you. Jury number 40, Mr. Suarez. Oh, okay, sorry, I'm gonna look in the wrong seat of my chart. Sorry, Mr. Suarez. Juror seat number 33, Mr. Lowe. Mr. Lowe, what about you? Would that be something that you would consider?
No.
No? Okay. Juror seat number 27, Mr. Cepero. Would that be something you would consider?
No.
Okay, thank you. Juror number 32, Mr. Lee. If you did not hear Mr. Brody or myself ask any questions of the witnesses, would that be something that you would consider during your deliberations if you're selected as a juror in this case?
No.
Okay, thank you. And juror seat number 29, Mr. Fickling. Would that be something that you would consider?
No.
No? Okay, what if Mr. Davis decided not to testify in this case and exercise his fundamental right?
No.
Okay,
I'm sorry, is this seat number 28?
29.
29? Okay, Mr. Fickling? Yes, thank you, sir. I'm sorry.
And then juror seat number 30, Ms. Hertz. How you doing, Ms. Hertz?
I'm doing okay.
If Mr. Brody or myself don't ask any questions of the witnesses, would that be something that you would consider or that would cross your mind if you're selected as a juror in this case?
No.
And what if Mr. Davis decided not to testify in this case? Would that be something that you would consider or hold against him?
No.
No? Okay, thank you so much.
All right. Yeah.
All right, so I want to move on to my last topic that I have here, and that is police officer credibility, okay? So in this case, there may or may not be some police officers that come testify in this case. And, oh, yeah, I'm sorry, this pillar doesn't let me see, I'm very sorry.
I'm sorry, who are we talking to here?
Seat number 20, Sheldon Rios. Back really quick back to the
This is Mr. Who, I'm sorry?
Rios.
Juror seat number
Mr.
20.
Rios, okay, seat number 20.
Yes. Back to the previous question about the lawyers. May I ask what the purpose of the lawyers is in a criminal court?
What the purpose of the lawyers are in criminal court?
Yes.
So I'm here right now asking you questions, right? Mr. Brody and I have no intention of sitting here playing cards, twiddling our thumbs, using our phones. But the important part is that you understand that even though we choose to ask questions, we don't have to. The burden lies solely on them. Assuming that Mr. Davis wasn't here, Mr. Brody wasn't there, and I wasn't here, the case can go forward with just the state. Does that make sense?
Yeah, I mean, yes, the lawyers are here. Witnesses will be called to testify. And, you know, if they feel they need to ask questions, they're going to get up and ask additional questions. Because what the witnesses say, that's evidence. That's the evidence. Okay?
Oh, so they asked the witnesses questions.
What?
They, the lawyers asked the witnesses.
The lawyers ask witnesses questions. That's how you get the information that comes from the witnesses. Anything the lawyers say is not evidence. You get the evidence from the person on the witness stand. Okay?
Okay.
Okay, very good. Thank you.
Thank you, Mr. Rios. All right, so my last segment of questions has to do with police officers. Now, the law says that you are required to believe a police officer versus a civilian witness have the same starting point before they even begin to testify. Meaning, you are not supposed to say, well, because a police officer is a police officer, I'm going to believe them more. Or on the opposite side of the spectrum and say, you know what? Because he's a police officer, I'm going to believe him or her less.
And the reason for that is we're all human. Police officers are to be treated like any other witness when they testify in terms of how you assess their credibility, whether you find them believable. They could be mistaken. They could be untruthful. They could be confused. They have a poor perception, just like any other human witness. Question, go ahead, counsel is going to ask you now.
Thank you. All right, my question is for juror seat number 2, Miss Alfonso. How you doing? Good. Miss Alfonso, would you believe that a police officer is more likely to tell the truth just because they're a police officer?
No, definitely no.
Okay.
Everybody have, the right to be credibility. That depends on what you do and.
Okay, thank you so much. Juror seat number 7, Miss Cole. How you doing, Miss Cole? Same question for you. Would you believe a police officer more just because they're a police officer?
No.
No? Okay, thank you very much. Juror seat number 15, Mr. Leon. Same question for you? No? You would believe him the same as any civilian witness?
Yes.
Okay. Juror seat number 19, Ms. Perez. Same question for you?
No, I wouldn't take his word over anyone that would be impartial.
Okay, thank you so much. Juror seat number 24, Alvarez. How you doing, Mr. Alvarez?
How you doing?
Same question for you. Would you believe a police officer more just because they're a police officer?
No, I would not.
Okay, thank you very much. Juror seat number 26, Burles. I pronounced it right? Okay, thank you. What about you? Would you believe a police officer more just because they're a police officer?
No.
Okay, thank you very much. Juror number 31, Ms. Knight.
No, I wouldn't.
Okay, opposite question as well. Would you believe that a police officer is more likely to not tell the truth because they're a police officer?
No, I believe they would tell the truth. I would give them the benefit of the doubt.
Okay, well, I guess my question is, do you treat a civilian and a police officer on equal footing?
Yes. I would.
Okay, thank you so much, Ms. Knight. And then right behind you,
34.
Jersey number 34, Mr. Noel. Would you believe a police officer the same as you would believe a civilian witness?
Yes, ma'am. They're both human beings. They're both equal.
Okay, thank you very much. All right, so just a couple of quick questions that I have for some specific jurors, and I will be done. Thank you, everyone, for your indulgence throughout these questions and this process. All right, juror number 3, Mr. Barrio. You indicated in your juror questionnaire of whether you or a close friend were ever accused of a crime. Do you feel comfortable talking about that? Yeah, you, in your questionnaire, you indicated yes to whether or not you or a close friend had ever been arrested or accused of a crime. Do you
Oh,
feel
me, DUI.
do you feel comfortable talking about that?
Yeah. sure.
Anything about that experience do you feel affects your the way that you will view this case?
I don't think so, no.
Okay, thank you very much, Mr. Barrios. Juror number 7, Ms. Cole. Hi, Ms. Cole, you indicated in your juror questionnaire whether you, that yes, you or a close friend or family member had been a victim of a crime. Do you feel comfortable me asking about that?
Yeah, sure.
Anything about that incident do you feel will influence the way that you think about or hear evidence in this case?
No.
And you,
And the reason, again, understand the questions about this, because you filled out and responded in your questionnaire, is to make sure, and you need to tell us otherwise, it's okay, no one's going to get in trouble, is that, for example, anyone who's ever been accused of a crime or someone close to them been accused of a crime, anyone who's ever been the victim of a crime or someone close to them been a victim of the crime, the reason why we ask follow-up is we have to make sure that based upon that circumstance, that you are not going to have any bias, sympathy, or prejudice for or against the state or the defense because of that experience. Okay, that's, I want to explain so you understand why the questions are going into a little more detail. Go ahead, counsel.
thank you, Your Honor.
Mhm.
All right, and Ms. Cole, you also entered in your jury questionnaire that you or a close family member had been arrested or accused of a crime. Is anything about that do you believe influences the way you will view this case or process evidence in this case?
It was a useful fist fight.
Okay, thank you, Ms. Cole. All right, juror seat number 12, Ms. Dania Gonzalez. Ms. Gonzalez, you indicated on your questionnaire that you have both a close friend or family member that has been a victim of a crime and you or close family member or friend has also been arrested or accused of a crime. Anything about those two incidents do you feel will affect you in the way that you process this case?
No.
No? Okay, thank you very much. And next one that I have is juror seat number 16, Mr. Lyons. Mr. Lyons, you indicated in your questionnaire that you or a close family friend had been the victim of a crime. Anything about that incident do you feel affects the way you will view the evidence in this case?
No.
Okay. Juror seat number 18, Mr. Millet. You indicated in your jury questionnaire that you or a close family member had been a victim of a crime. Do you feel that anything about that incident will affect the way that you view the evidence in this case?
No.
Okay, thank you very much. Juror seat number 19, Ms. Perez. You indicated in your jury questionnaire both that you or a close family member or friend had been a victim of a crime and a close friend or family member had been arrested or accused of a crime. Anything about those two incidents do you feel affects the way you process or view the evidence in this case?
No, not at all.
Okay, thank you very much. I'm almost done here, everyone. Thank you for your patience. Juror number 20, Mr. Rios. You indicated the same in your questionnaire. Anything about that do you feel affects your ability to view the evidence in this case?
Not at all.
Okay, thank you very much. Juror seat number 23, Ms. Alonso.
Same question?
Actually, I'm sorry. It's juror number 24. I apologize. Juror number 24, Alvarez.
Yes.
Anything about those two situations that you indicated in your questionnaire you believe will affect the way that you process evidence in this case?
No, it will not.
Okay, thank you so much. Juror number 25.
Seat number 25.
Sorry, juror seat number 25,
is-
Batista.
Same question.
Same question.
Nah, it wouldn't affect.
Okay. Juror seat number 27, Sapero.
Juror seat 27, Sapero.
Yes.
Will that
Anything-
have any impact at all?
You indicated in your jury questionnaire that you or a close family member or friend had been the victim of a crime. Anything about that do you feel would affect the way that you view evidence in this case?
No.
Okay, thank you very much. Juror seat number 29, Mr. Fickling. Anything about that would affect your decision or the way you view evidence in this case?
No.
Thank you. Juror number 30, Ms. Hertz. You indicated two different situations in your questionnaire. Anything about that do you feel would affect your decision in this case?
No.
Okay, juror number 31, Knight. You indicated two situations as well. Do anything about that affect your decision or the way that you will view the evidence in this case?
No.
Thank you. Juror number 33, Low, same question? No, thank you. Juror number 34, Noel?
No.
Thank you. Juror number 35, Pardo, anything about that, those situations would affect the way that you view the evidence in this case?
No.
All right, and last but not least, juror number 36, Ms. Perez Texador. Anything about that situation where you or a close family member were a victim of a crime, do you feel would impact the way that you view the evidence in this case?
No.
Okay, thank you very much. Everyone, I want to thank you for your time and attention throughout this process. I want to thank you on my behalf, on Mr. Brody's behalf, but most importantly, on Mr. Davis's behalf. Thank you, everyone.
All right, thank you, counsel. Ladies and gentlemen, we'll take a 15-minute break. Do not discuss this case with each other or with anyone else. The lawyers and I are going to go into a courtroom, address the matter, and we're going to come back here and let you know whether or not you've been selected to serve on this case. Okay? Also, please don't do any research to gather information. I'm sorry. We're going to take 15-minute break. The lawyers and I are going into a courtroom now. We're going to discuss all of you. We're going to select a jury. Be back here. The bailiffs will make sure you're back in here no later than 12:25. About 15 minutes. Do not discuss the case. Do not do any research about the case. We'll be right back. Thank you. before we bring into the main courtroom. We want to continue to be conservative in our social distancing and so on and so forth, so that you can feel comfortable. Okay? You have my card. If you have a problem or a question, any issues, call the number. If you're running late, there's an emergency, you got to let us know because we're going to wait for you. You can't start till you're all here. Any questions? Seeing no hands. Wonderful. We'll see you all tomorrow, no later than 8:45. Thank you.